I think that the NGO is talking. They have not told us they have gone to court. That's it. They are talking about the jurisdiction of the Federal High Court, but the only aspect that appears to fall within the jurisdiction of the Industrial Court looks like the appointment of the clerk and all that. But it's still politically a constitutional issue, from what lawyers say. I've sought legal advice on all this, and that the position of the law is that the clerk of the House is an appointee of the legislature, right? Not civil service, strictly speaking. But this one is a coincidence. In this one is that he was a civil servant when he was appropriated and appointed clerk. So there's a dual issue there. And then the next issue is the jurisdiction of Federal High Court, which said the legislature should not be interfered with. That nobody, no arm of government can interfere with the workings of the of the Assembly. That's a constitutional provision, and it's on that reason that even the Federal High Court granted that injunction against the state government. So these are complicated issues, but generally, all this may not be in the interest of the state, generally. But in politics, you talk about political interests. That is what is on this table. Yeah.
Well, for me, until the legislature comes to
independent, yeah.
These are the issues that always current. Okay, when you look at it, the two school of thoughts or the two arguments from that.
Yes.
One argument is coming from the legislature. There is a statutory provision for the appointment of the clerk and the
deputy clerk, yeah.
And it's the express reserve of the Speaker and
of the House. Good.
So now means that they are the
House.
And the Constitution also grants that for them to be removed,
it has to be the House.
Emphasis on removal. For them to be removed also has to be by decision of the same
exactly of the House.
The House and the Speaker. But the question is the governor moving to remove them?
Yes, he deployed them because they were initially civil servants. Then they appropriated them and appointed them. That is the confusion there.
Now,
that's why somebody was talking about industrial court.
The governor.
You understand what I'm saying?
The governor is not seeking to remove them.
No, the head of service redeployed them. Yes.
And that redeployment falls under the purview of the head of service, which is the governor.
Yeah. Now the confusion is: can the head of service remove a legitimate appointee statutorily of the legislature? The answer is no. But the question is, what was the original status of the civil servants, of the speaker, the clerk, and the deputy? It is on that the head of service has acted. Go ahead.
Okay, I think that
there are two. There's a confusion there.
First and foremost, I think that the judiciary, first and foremost, has continuously taken decisions that are not from the point of information, from the point of knowledge. The question I want to ask is this: the clerk that we're talking about, like you said, it was redeployed from his originally civil servant, and then was appropriated to the legislature. Now, who pays the clerk?
What is it
the state assembly that pays the clerk, or the state government that pays the clerk? If the state government is the one paying the clerk, it automatically means to me that the clerk himself is a civil servant employed by the River State government and can be transferred at any point in time by the appointing officer.
If he's so. If
the governor decide that he has, working with the head of service, decide that this clerk has stayed for a long time in this department, let us move him to another place. Let us bring another person to run the affairs of the state assembly. I think that there is no reason why anybody should go to court to say that governor cannot do that. That's on one side. Then the other side is also a dangerous trend. I believe that any governor who is being treated unfairly, for instance, will take some decision to be able to escape from the unfair treatment being meted out to him by the whether it's legislature or the judiciary. So I think that the transfer of the clerk, so to say, that has brought this this
Deployment.
court injunction and this reaction we are getting now is because the governor is trying to rearrange the relationship between the legislature and the executive. I want to believe that the clerk is a kind of the gatesman between the legislature and the executive. So he's trying to rearrange the whole place so that the state can activities in the state can flow very well. That's on one side. Then the other side is that the governor cannot go as far as transferring or redeploying the clerk if the governor was not properly informed that, see, this clerk in this assembly is an appointee or an employee of the state government. So the governor simply said, you are my appointee, you are my employee.
No, employee, not appointee.
Okay, you're employee. Okay, you are my employee. Haven't served in the state assembly for a long period of time. Come out from there. Let us see your experience in some other place. I don't think I don't think there's any problem.
You know that the
sorry,
clerk of the house is like equivalent to the chief registrar of the High Court. The chief registrar of the High Court is a magistrate, a chief magistrate, appointed by the chief judge and Judicial Service Commission. In the same vein, you cannot wake up and say you are removing, no governor can wake up and say I'm removing the chief registrar of the judiciary.
If I may,
sorry, you talk. The complication in the matter was because the clerk and his deputy were originally civil servants who were appropriated and appointed by the house. So their current status is that they are appointees of the house. So it is for the law to unbundle the complication, the conundrum.
No, you can't say that. You can't say that they are appointees of the house. If we have the information that originally they were civil servants, they were appropriated
and appointed.
So it simply means that the state government that employed them ab initio is simply saying, you are my employee, so come and work for me. It's as simple.
Okay, appoint another class.
So if you are a state assembly, if you feel that I have done something wrong as a government, go and appoint your own clerk, and then let us move on. And of course, you know that the most state assemblies are not so buoyant, or even if they are buoyant, they are very, very greedy. Many of them are very greedy. They don't want. In fact, if the governor can pay all the staff of the state assembly, they don't mind. All they're interested in is to get their allowance and get their constituency allowance and get away. So I think that was the reason why the appropriation happened in the first place. Because for any speaker that understands what the clerk is, you should be able to appoint that clerk on your own, so they can have firm control of what the clerk does.